Hi guys, welcome to my channel. Please hit that like button and subscribe if you haven't already. So it's been a minute since I did a case update for you guys, and I thought I would give you one today. We're going to talk about the case of Maurice J. Scott from Love and Marriage Huntsville against a couple content creators here on YouTube. Before we get into the court documents, I want to say all the information in this video is alleged. All commentary will be in my very own opinion. This video is strictly for entertainment purposes only. So we know this case is not new. It has been going on for a while now. Maurice did start it by filing a defamation lawsuit against a couple content creators. And then one of those content creators responded and filed her own countersuit. So they were due in court today down at the Madison County Courthouse. And Maurice actually filed a motion and a response. And that's what we're going to go over today in this video. So the first document is on the screen, and we can see that it was electronically filed on April 15th, 2025, which is today's date. We have Maurice J. Scott Sr. listed as the plaintiff, and then we have Anonymous listed as the defendant. And the motion is titled Response to Helen Griffin's Motion for Default Judgment. Comes now plaintiff / counter defendant Maurice J. Scott Sr. hereinafter Mr. Scott, and files this response to defendant / counter claimant Helen Griffin hereinafter Griffin. Motion for default judgment. Griffin's motion is due to be denied because Mr. Scott filed an answer to Helen Griffin's claims before a judgment was entered by the court. Mr. Scott filed an answer reply to Griffin's claim, and because the law is that clear, an answer filed before the court enters judgment cures its untimeliness. Because of the foregoing, Griffin's motion is due to be denied. Material facts and procedural history. Number 1. On May 3rd, 2024, Griffin filed her answer to plaintiff's complaint and her first counter complaint against Mr. Scott. Number 2. On May 6, 2024, Griffin filed an amended complaint. Number 3. On May 24, 2024, Griffin again filed an amended answer, counter complaint, and cross complaint against Mr. Scott. Number 4. Mr. Scott filed an answer to Griffin's claim on July 11, 2024, as the document is on its face named plaintiff / counter defendant's answer to defendant / counter claimant Helen Griffin's counterclaim. Number 5. In Mr. Scott's reply, in parentheses answer, stated he denies all material allegations and demands strict proof thereof, and stated his affirmative defense. Number 6. On November 11, 2024, Griffin filed a motion for court to take notice and enter order of joint stipulation / admission from Scott. Number 7. In Griffin motions, she claimed on July 12, 2024, the day after Scott's invalid and untimely answer appeared on the record on July 11, 2024, forming the admission / stipulation, Griffin immediately filed her rejection / objection and deemed waiving nothing such conduct as an admission. Number 8. This court denied Griffin's motion for the court to take notice and enter an order of joint stipulation / admission in Griffin's favor. Number 9. On January 7, 2025, Griffin again raises the same claims that have previously been denied, that Mr. Scott failed to file an answer to her claims, and that because Mr. Scott filed an untimely answer, she is entitled to default judgment. Legal argument. Griffin's motion is due to be dismissed because Mr. Scott answered Griffin's amended counter complaint against Mr. Scott before Griffin filed a motion for default judgment. And before the court entered judgment in this matter, the motion for default judgment is also due to be denied because this court has previously denied Griffin's exact same claims in her motion for court to take notice and enter order of joint stipulation / admission. Part 2 is titled Griffin's motion for default judgment fails because Mr. Scott filed a reply / answer to her counterclaims. A. An answer filed before entry of default judgment cures the failure to answer. Under Alabama Rule Civic Procedure 8D, the averments in a pleading to which a responsive pleading is required, other than those as to the amount of damage, are admitted when not denied in the responsive pleading. A court's application of Rule 8D does obviate the need for proof of an admitted factual averment at trial or in a motion for a summary judgment. The Supreme Court of Alabama has held that an answer filed before entry of default cures the default. The Supreme Court reversed a default judgment entered by the trial court when a defendant had filed its answer before the hearing on the plaintiff's motion for a default judgment, holding that the filing of the answer cured the default before any default judgment was entered. Thus, the default judgment should not have been entered. In Winford, the mother had filed an answer to the father's custody modification petition before the default hearing. Like the Winford case, Mr. Scott filed his answer before Griffin filed a motion for default or a motion for default had been heard. See document 140. Specifically, Mr. Scott has denied all material allegations in his filed answer, thereby negating any of Griffin's claims that he had not denied the responsive pleadings. On June 24, 2024, the court denied Griffin's motion to dismiss Mr. Scott's complaint. The indisputable records reflect from the court's denial of Griffin's motion on June 24, 2024 until July 11, 2024, the date Mr. Scott filed his answer. Griffin failed to file a motion for default judgment or any other motion. Further, the record is devoid of Griffin's ever filing a motion for a default judgment, much less before Mr. Scott filed his answer. Even if Griffin had filed a motion for default judgment, Winford instructs that Mr. Scott's filing of his answer before the court entered default judgment cured any default, and Griffin would not be allowed to rely on Mr. Scott's failures to answer. Therefore, even if Griffin had filed a motion for default judgment, which she did not, that too should be properly denied by this honorable court. B. Griffin's amendments to her complaint replace her previous complaint. Griffin misstates the facts applicable to Mr. Scott's answer to her counterclaims in her amended complaints. An amended complaint supersedes the original complaint, Holcomb v. Maurice. Specifically, on its face, Mr. Scott filed a document named plaintiff / counter defendant's answer to defendant / counterclaimant Helen Griffin's counterclaim. See document 140. Mr. Scott's answer was filed after Griffin's amended her complaint for the third time regarding causes of action and facts alleged against Mr. Scott. Griffin has not filed an amended counterclaim against Mr. Scott alleging any new cause of action. Therefore, because Mr. Scott has filed an answer to Griffin's last amended countercomplaint against Mr. Scott, her motion for default judgment is due to be denied. C. Mr. Scott's renewed answer to the complaint. If the court was to construe Griffin's amended claims against OWN as an amended claim against Mr. Scott requests that this court renew his answer to any of Griffin's amended claims, including all of his previously asserted affirmative defenses as outlined in the accompanying Exhibit 1, specifically including but not limited to privilege, as Mr. Scott has alleged litigation privilege in his answer to Griffin's claim. Okay, so we're going to go on to the next document, which will be the Exhibit 1. So this document is also on the screen. We see it was also electronically filed today on April 15th. 2025 in the Circuit Court of Madison County, and we see right there it says Exhibit 1 big and bold. Let's scroll down to the document. Maurice J. Scott listed as an individual and the plaintiff. Anonymous is the defendant, and it is titled Plaintiff / Counter Defendant's Answer. Comes now plaintiff / counter defendant Maurice J. Scott Sr. hereinafter Mr. Scott, and hereby files this answer to defendant / counterclaims complaint. Mr. Scott states as follows. Defendant denies all material allegation and demands strict proof thereof. Defenses. Number 1. Plaintiff's complaint fails to state any claim upon which relief may be granted. Number 2, lack of damages. Number 3, contributory negligence. Number 4, waiver. Number 5, no adequate remedy at law. Number 6, failure to mitigate damages. Number 7, condition precedents. Number 8, failure to plead fraud with particularity. Number 9, no reliance. Number 10, punitive damages not permissible. Number 11, unilateral mistake of fact. Number 12, scrivener's error. Number 13, privilege. Number 14, immunity. Number 15, no private right of action. Number 16, failure of condition precedent. Number 17, misrepresentation. Number 18, lack of casual relationship. Number 19, acquiescence. Number 20, failure to preserve confidentiality. Number 21, good faith. Number 22, no intent to defraud. Number 23, immunity. Number 24, statement is privileged. Number 25, no government action. Number 26, statutory compliance. Number 27, circuitry of action. Number 28, unclean hands. Number 29, in pari delicto. Number 30, supervening cause. Number 31, intervening cause. Number 32, preemption. Number 33, claimant's own conduct or by the conduct of his agents, representatives, and consultants. Number 34, defendant may have additional defenses and therefore reserve same. Wherefore have fully answered defendant's praise this honorable court for an order dismissing the instant action with prejudice at plaintiff's cost, attorney fees for defendant's costs herein expended, and for such other and further relief as the court deems just and proper in circumstances respectfully submitted. And we see that the date on that was July 11th, 2024, and it was submitted by Maurice Scott. This was document 140 that he referred to, where it was the certificate of service sent to everyone on the case. So, you guys, that was exhibit 1, where Maurice is stating he did indeed answer. So, there should not be a default judgment set against him. So, you guys, while I was finishing up the video for the other court documents, the order was actually issued in the case. So I'm going to go ahead and show you guys. The document is on the screen. It was again electronically filed today, April 15th, 2025, in the Circuit Court of Madison County, Alabama, with Maurice Scott listed as the plaintiff. And you see Anonymous here for Hot Tea and Black Titanic are listed as the defendants. And it says, order. This cause came before the court on April 15th, 2025 for a hearing on various pending motions and responses thereto. Having considered the arguments and representations of counsel, and after due consideration of all relevant and applicable law, it is ordered, adjudged, and decreed by the court as follows. Number 1, the plaintiff/counter defendant's motion for judgment on the pleadings and fees and costs under the Alabama Litigation Accountability Act filed on January 6, 2025 is hereby denied. Number 2, Helen Griffin's motion for this court to enter a default judgment against Scott without delay filed on January 7, 2025 is hereby denied. Number 3, the third-party defendant, Oprah Winfrey Network, LLC's motion to dismiss Helen Griffin's third amended cross-claim filed on January 10th, 2025 is hereby granted, done this 15th day of April 2025, and it is signed by the judge. Okay, you guys, there we have it. So it seems that number 1 is in regards to Maurice Scott, because he will be listed as the plaintiff in the original suit, and he is listed as the counter defendant in that counterclaim against him. So his motion was denied as far as the fees and costs. And then Miss Black Titanic, she entered to get a default judgment against Maurice Scott. However, that was denied. And then the third one is in reference to OWN, and it is granted for them. The motion against OWN has been dismissed. Once again, y'all drop down in them comments. Let me know what y'all think about this. I'll update y'all if they go ahead and file another amended complaint, because that's what they've been doing. So yeah, I'll keep you guys updated as the documents become available. Bye.